Good morning. Be seated. Now is the time for oral argument in cause number 1 CV140616, ABN Investments LLC, excuse me, versus James G. Garvey Jr. and Julie Lynn Garvey, husband and wife. For your information, these proceedings are being both audio and video recorded, so barring any unforeseen problems, you will have the ability to critique your performance today on YouTube in a couple of weeks. Counsel, each side will be entitled to 20 minutes, and we would ask that you respect that time period. Again, excuse me. The timer located on the podium will let you know how much time you have left. I doubt if either of you, that's going to be a new concept too, but we're letting you know. An appellant, if you wish to reserve any portion of your 20 minutes for rebuttal, please let us know so we can avoid taking up all of your time. However, ultimately, your reserving of rebuttal time will be up to you. We've reviewed the briefs this morning. We have conferenced the case this morning, so we are well aware of the facts and issues attendant to this argument, and that might help as you figure out what it is you want to present and where you want to go with your presentation today. Counsel, when you come to the podium, I would ask that you state your name and who you represent. And with that, counsel.
Thank you, Your Honor. Stuart Halstead, appearing for appellant, ABN Investments. I'd like to reserve 5 minutes for a rebuttal. Your Honor, this case involves defendants attempting to avoid liability on the basis of an order that was obtained by misrepresentation and which has been vacated by the bankruptcy court. Defendants also contend that they met the condition of substantial consummation, even though the bankruptcy court has now expressly found that the plan was never consummated. We respectfully submit that these arguments should not prevail and the decision below should be reversed. The critical order and the last order in this case, as the only applicable order from the bankruptcy court, is the order which held vacating the prior closing of the estate. That order specifically stated that the court would not have confirmed the plan but for misrepresentations, and it further found that there had been substantial consummation of the plan. In vacating the order, the defendants rely on to establish the condition precedent. The bankruptcy court ruled that one representation was, excuse me, obviously false because the debtor has not now and now says it cannot pay administrative fees. The court further held, as to a non-disclosure as to tax returns, that the court considers this non-disclosure another misrepresentation to the court. The court concluded, to summarize, only because the debtor was less than truthful that it was able to have his plan of reorganization confirmed. And that plan of reorganization is what fulfilled the condition precedent to the release in this case. When that falls, then the condition precedent falls and the release is no longer effective, and then ABN was entitled to sue, which it did.
This sounds like an equitable tolling argument.
I'm sorry, Your Honor.
This sounds like an equitable tolling argument.
I'm a little hard of hearing.
Okay. This sounds very much like your equitable tolling argument, not a limitations argument.
Well, it's not equitable tolling gets into it, but it is also the issue of when we could bring the suit. As long as there was a bankruptcy court order in effect, we could not have brought the lawsuit because the condition precedent was by the bankruptcy court's orders met. But
you weren't barred by the stay for all this time from bringing the lawsuit. It was the conditional release, yes? It wasn't the stay that barred you, but rather the conditional release?
Correct. It was not the bankruptcy stay. It was the condition for release. It was first there were negotiations that we were going to get paid out of the plan. Then there was the findings of, then there was the plan being confirmed. So once the plan is being confirmed, there's the issue of the release being effective. So it wasn't the bankruptcy stay, to answer your question.
But the conditional release then is being used now as a tolling agreement, not as a conditional release.
The condition of release, I suppose in a sense that's true, but it's used as tolling in that we could not have brought suit as long as that bankruptcy order was in place, approving the plan and essentially finding substantial consummation. And the place to reverse that order was what was the bankruptcy court. So as long as that plan was as long as those orders were in place, we could not have brought an action. We did bring an action and dismissed it as to the Garveys because of those orders. So it was much like there was a settlement agreement in place. We could not have brought an action as long as the settlement agreement was in place. And once the settlement agreement was or was not consummated, then it gave us the right to bring the action.
Okay, but if you're going to enter into a settlement agreement that contemplates tolling of the statute of limitations, shouldn't the agreement say that?
I don't think it has to, Your Honor, because you have, this is actually a little bit different than the settlement agreement causing it. It's an event occurred, or an alleged event occurred. This event occurred, tolling it, because we could not have brought the lawsuit while the first court's order was in effect. It's really not so much the settlement agreement as a condition being met. It's not something that needs to be said. It's something that occurs as a matter of the bankruptcy court entering the orders which it did. The bankruptcy court enters the orders which it did. That precluded us from filing the lawsuit. You wouldn't put something in the lawsuit or in the settlement agreement, if these orders are procured by fraud and they get reversed, then we can bring an action. It's something I think that's implied in good faith. And I think what's important here is the misrepresentations that were made to the bankruptcy court. It was only by the misrepresentations that they were able to obtain the orders on which they're relying to fulfill the condition precedent. So
let me ask, why wouldn't you or couldn't you put provisions in that order of from the bankruptcy court saying, hey, if this is set aside, if this is appealed and reversed, if this is vacated, then you waive certain obligations or you waive limitations periods, something like that? Why wouldn't?
Well, I suppose there's lots of things you could put in hindsight of what you put in, but it's almost a matter of law that it's waived, that it's told, because you can't bring the action. It's not a situation where you're waiting for something to happen and you're saying, okay, while we're waiting for this to happen, we're going to toll the period. This is something that happened. They got the order of substantial consummation. They got the order confirming the plan. They got that by misrepresentations. Then you go back. Now, they have a finding, but the finding doesn't mean that it's true. The court could find something and later find that their finding was incorrect.
And I understand that, but at some point in time, it seems like that has to sort of end, doesn't it? I mean, I guess I'm struggling with this.
Well, it ends when there's no misrepresentation. I suppose you could argue latches or something of that nature, but the arguments you're making are really not arguments which were made by the appellee in its brief.
Well, the arguments that you're making, I think, are arguments that relate primarily to the motion for new trial, which raised some of these arguments for the first time. And to conflate the concepts of waiver and tolling is quite a leap. It seems to me that a party seeking a release does not assume when it gets that release that you're simply tolling the statute of limitations so you can be sued 10 years later.
Well, it's not tolling the statute of limitations. It's really the first. There's a couple issues there. I guess the first argument is that the lawsuit could not have been brought until the incorrect order of the bankruptcy court was vacated. The cause of act, that's not an equitable tolling argument. That's the right to bring the action in the first place. You have a situation where the condition of release was met. And if we brought a lawsuit in Superior Court, they would say, and they're saying now for a vacated order, they certainly would have said it for an order that was in effect. They say, here's the order confirming the plan. And the bankruptcy court's judgment is entitled, actually, I don't think the Superior Court really can attack or challenge the bankruptcy court's argument or the bankruptcy court's judgment. So you have a situation where there was no lawsuit to be brought in the first place.
But the lawsuit you ultimately brought was on the guarantee, not on breach of the conditional release.
Well, there is a breach of good faith and fair dealing covenant brought, which
but the underlying liability is on the guarantee itself, and there was no requirement that the conditional release spring into being. If there was a bankruptcy and you wanted to sue on the guarantee, there's a way to pursue those claims through the bankruptcy. So it seems to me that the date of accrual is the date of breach. And here the breach was the non-payment, so I don't understand why the date of accrual would be delayed until some hypothetical possible future bankruptcy order.
Well, the release was not effective until these conditions were met. The conditions were met, so then we do not have a lawsuit based on the release. I'm obviously not making that my point clear, but the lawsuit, our current lawsuit, could not have proceeded but for the vacation of the bankruptcy court's order finding substantial consummation and finding and finding the plan confirmed. Once that's released, then we could proceed. Until then, we could not have even proceeded in bankruptcy court at that point. And when does it end? It ends at some point, but not when you have an ongoing bankruptcy proceeding, which there was an administrative claim filed. And Judge, when you get into the question of when does it end, we're going down a rabbit hole here, which is how much are we getting into what the bankruptcy court found and what the bankruptcy court didn't find and what happened in the bankruptcy court. And with respect, we really should be looking at the last bankruptcy court order, which says there was not substantial consummation of the plan. The conditions of release were not fulfilled, and that's really the bankruptcy court's most recent and applicable order. And until then, there was no cause of action. They knew that they owed the money. They knew they obtained the plan by misrepresentations. They really shouldn't be rewarded for pulling the wool over the court's eyes. And Judge Swan, you mentioned about the equitable tolling argument being raised in the motion for new trial. They do not argue that we failed to raise it in timely in the trial court. That's not part of their appellate or their appellate brief. If it had been, we would have addressed it. And there are cases which hold that as long as you assert the facts which form the basis for the claim, that is sufficient. We cite those on page 24 of the brief, the Kozman case, and also the Hogosi case, which we cite on the same page. Both say that if you've alleged the facts for equitable tolling, that's sufficient. And we allege the facts.
Where did you allege those facts?
In the complaint, Your Honor. In the complaint, we say that the condition precedent was not met. We say that we allege that there was the prior order. We allege that there was the reversal of the order. We allege that we brought an earlier action and dismissed that.
But when faced with a motion to dismiss, those equitable concepts weren't raised.
They were raised in those facts were raised. Those facts were raised in response to the motion to dismiss.
But you're just saying that by reciting the facts as you assert they occurred in the course of the case, that someone is supposed to take from that resulted in equitable tolling.
I'm saying that it is close enough that you have the facts alleged sufficiently to establish the claim and allow us to make that on appeal, especially when they have not raised that as an issue.
Aren't you just saying the flip side of the facts were there if you'd raised them to the court?
Well, we did raise them to the court. We did raise the issue that we could not have brought the action. We could not have filed the complaint until we got the order vacated. So the facts were there. The rule of failing to raise an argument is really one of prudence and procedure. It's not a jurisdictional rule, and as I'm sure you know better than I do. I think especially where the appellee has not raised it.
Has not raised what?
I'm sorry?
Has not raised what?
Has not raised the issue that equitable tolling was not raised below. I believe, was that the point you were making earlier, Judge Schwan, that I wanted to?
That it was raised for the first time in the motion for new trial.
Right, but that and if the suggestion was we could not raise it here, I wanted to address that because we didn't have an opportunity to address that in the brief because it was never raised, and the purpose of the rule for requiring an argument to be made.
But you're the appellant.
I'm sorry?
You're the appellant.
Yes.
So you could have raised anything in your opening brief that you felt.
Well, we weren't going to raise that. It hadn't been raised until the motion for new trial.
Well, okay, but understanding that the general direction of the case is not to consider arguments raised for the first time in the motion for new trial for obvious reasons. Can you explain now why the issue of equitable tolling wasn't raised until that point?
I can't get into the mind of the lawyer who filed the response, but reading it seems clear to me, and obviously I'm in the minority. I may be in the minority on this, but that you could not bring the action until you had the condition precedent resolved. You had a finding that the condition precedent was not met. At the time the case was originally, with the first order, the condition precedent was met.
But let me ask, your client and your predecessors had acknowledged that the claim accrued far earlier. They'd sued on it, right?
That's correct.
And I read your response to the motion to dismiss as arguing solely that the accrual date was far later than the defendants argued in their motion to dismiss. That was it.
Well, I think that the basis for that accrual date was because of the misrepresentations and because of the existence.
But the only way I struggle with that because that sounds so much like the equitable doctrines that you raised in your motion for new trial, but that weren't raised in your response to the motion to dismiss.
I think that's our point. I think what you say where you struggle with and it sounds so much like it, that's because it is. And that's what the cases allow you to do where it's been substantially raised. You can consider it on appeal.
I think it's fair to construe that the trial court, in ruling on the motion to dismiss, didn't construe your response as raising equitable defenses to the limitations period. Is that fair?
I can't speak for the trial court.
Well, I think I understand that, but I've read the ruling.
It did not say it didn't say anything about equitable tolling as I recall. But Your Honor, I think
think would be surprising, right? Because it wasn't expressly raised in the moving papers in the response.
Well, I guess I think it's important to look at how this came up. This came up on a motion to dismiss.
Right.
Oral argument was requested, but was not granted.
Right. Making the briefs even more important.
Well, but oral argument was requested.
Understand.
And the purpose of really the rule of not considering arguments made below are to give the trial court an opportunity to rule on it, which they did, certainly on the motion for new trial. We have to agree that.
Is there any indication the trial court substantively ruled on the equitable claims in the motion for new trial? I didn't read that. I didn't see that.
I think in denying the motion for new trial, it ruled on, on that issue.
I think it found the new trial motion was not well taken. Fair?
Yeah.
I mean, but I don't see any language suggesting it considered substantively the equitable claims, equitable defenses really raised for the first time in the motion for new trial.
Well, I think it's implicit that it would consider, everything where it does not specifically say. I think the general rule is that where the trial court doesn't make a specific ruling, it encompasses everything in its ruling, which would encompass considering the equitable tolling arguments. If the court.
So without that even being raised, the court should have just taken it upon itself to say, well, no one recognizes this and no one has addressed this in this form, I'm going to just assume that there was equitable tolling here, or I'm going to find a basis for equitable tolling where no one asserts that it exists without me assuming that?
Well, on the motion for new trial, the court wouldn't have to do that. It had been raised on the motion for new trial. On the motion to dismiss, the question is what do we need to raise in order to make the argument on appeal here? And on appeal, I think we raised it sufficiently, to make that argument, because there are and the appellee had the opportunity to make a record on this, and the appellee, I want to emphasize again, the appellee hasn't even raised this argument. So we really haven't had a chance to fully, explore it. Just as in the trial court, we didn't have the chance to fully explore it. I see my time's up.
We are, counsel. Thank you.
Thank you for your time, Your Honors. Dennis Hall for Jim and Julie Garvey, who are the defendants and respondents in this case. This is a case about finality. The Garveys have been involved in 4 different actions on the same note. They were sued in 2005, which I think, as the judges are pointing out, makes it difficult to say that there wasn't a beginning of the statute of limitations when they took the position at the time.
At least someone believed that the cause of action had accrued as of 2005, correct?
That is correct, and that was the prior owner of the note who they bought from. So essentially, it is the plaintiffs here who took that position at that time. And what we have here is. Then obviously they were the Garveys, although they weren't parties, and that's very important. They weren't parties to the bankruptcy case for the company IIS. They were collaterally dragged in order to make an agreement with the with ABN for other purposes, and that's beyond, at this point, beyond the factual development here, since we're at a motion to dismiss. And as part of that, they entered into the release. The terms of the release, and I think we've got 2 tracks here that the court has identified, I believe, correctly. We have one reason that this should be denied is that there's a specific release, the conditional release, and the conditions occurred. That's a contract. Then the court, I think, is incorrect in pointing out that equitable tolling has nothing to do with that issue, right? That's a contract issue. The other issue is the statute of limitations. If we start with the 2005 date, obviously a case brought in 2013 has statute of limitations issues, right? So we have the second case, the bankruptcy case. In 2011, oddly enough, the plaintiffs sued the Garveys again on the note, and then months later withdrew the suit. And then we have this action in 2013. Anyone should have seen that there were issues with regard to dismiss of release and the statute of limitations.
Counsel, so someone believed in 2005 the cause of action had accrued.
Yes.
Someone believed in 2011, post filing of the bankruptcy, that the cause of action had accrued.
Correct.
And that was voluntarily withdrawn, voluntarily dismissed.
Yes.
And then we get to 2013.
Yes.
Thank you.
Yes, that's why, and I'm saying this is about finality. Well, let's go down both paths here, because there are a couple of factual errors. I think that actually the appellants are in a worse position than even you think at this point. With regard to the contract, the release itself, the terms of the release are one page. And the issue simply is, and it hasn't been contested, whether substantial consummation, whether other terms of release conditions occurred. It all revolves around substantial consummation. And it is on the record, and in a motion to dismiss, one can look at records. The judge can do that without converting it to a summary judgment, that the bankruptcy court entered an order that affected substantial consummation. Substantial consummation is a term of art defined in the bankruptcy code. And it basically means that part of the part of distribution of the plan has occurred. Once partially it has occurred, then substantial consummation has occurred. In the trial court, in their briefings, the appellants have confused this and tried to say, well, the plan wasn't completed. That's completely irrelevant. Makes no difference. Once the substantial consummation order was entered, the conditions of the contract were fulfilled, and the Garveys were released. The second line, obviously, is the statute of limitations. Now, procedurally, you are correct that the plaintiffs really failed to raise issues with the trial court. And I think that procedurally the case that matters here is the McLeod case, which is, and I'm sorry, I remember cases by fact patterns. That's the case where a lawyer had a horrific series of events that prevented him from filing a complaint within a one-year statute of limitations. And in that case, the trial court denied him equitable estoppel of the statute of limitations. In the McLeod case, it points out that the procedure on a motion to dismiss, and that was a motion to dismiss case also, is for the trial court, that once a motion is made to dismiss a case based on the statute of limitations, when the plaintiff wants to argue equitable estoppel, they have the burden of coming forward with that defense. So here below, in the trial court, the plaintiffs had the burden of proving equitable estoppel. And as you can see from the record, they essentially offered nothing. What they've offered is simply pointing to the record of the bankruptcy court. And so we have one event in the bankruptcy court that matters. And this is very troubling because in the bankruptcy court, the plaintiffs here have essentially misrepresented what happened. And the plan went forward. There was a plan of reorganization. Substantial consummation order was entered, essentially 2007, I believe. After 2007, the company was unable, for different reasons, which doesn't really matter here, to fund the plan of reorganization. In 2013, there was essentially a motion made by the plaintiffs here to convert the plan of reorganization in the bankruptcy from a reorganization to a Chapter 7 case. The IIS, the company, did not object. They concurred, folded the table, and said, yes, we're not going to try to complete our plan of reorganization. We say we can convert this. It's important because there was nothing adjudicated. There was no hearing. There were no facts. There was no contest in the bankruptcy court about whether or not there was substantial consummation. Instead, if you read the order, what happened is the court made a comment, and the order was entered saying that that for the reasons stated, we will convert to Chapter 7. Now, for collateral estoppel, which I think is the correct issue here to occur, there has to become things. There has to be a prior adjudication. There wasn't. It has to be the same parties. In the bankruptcy court, the party was Integrated Information Systems. Mr. Garvey was not a party to that suit. So you can't assert collateral estoppel. Now, to step back one step further and say, well, what about it? We're looking at a contract. In that contract, as I think Judge Tuma correctly pointed out, ABN could have very easily put in a tolling agreement. Happens all the time. You draw up a contract and say, I'll defer. Because look what can happen. Who knows in the future when substantial consummation would have occurred, these conditions would have occurred. So when they drew up this agreement in 2006, I believe, they could have said, well, if things go wrong, we could have, our case is going to go away, certainly by 2011, by the statute of limitations. As part of our agreement, we want to preserve that. They didn't do that. They could have also, when the plan, and they were a creditor in the bankruptcy, they could have simply gone, and they had 20 days to object, I think it is in bankruptcy court, to the plan of reorganization. And it seems to me, if it was an important issue, that they were waiving their rights to sue the Garveys when that order was entered, that they would have scoured the order and could have objected at that time. From 2007 to 2013, they did nothing. They didn't go back to the bankruptcy court, they didn't have a hearing, they didn't develop a record. And then when we get to our case here in 2013, when you go through the pleadings, they didn't even plead in their complaint any reason to get around the statute of limitations or the release. There's nothing in those pleadings that really support it. Now, when faced with the motion to dismiss, it's clear that the burden goes to them to prove that one of these reasons, one of these defenses to either the agreement or to the statute of limitations exist. They didn't ask for a hearing. They didn't proffer any real evidence. In fact, when they got to the motion for reconsideration, the motion for reconsideration says that it's a matter of law that they're arguing. They didn't object to anything factually. They didn't tell the judge, we needed a hearing, we need to develop these facts. So again, they essentially waived all of these arguments by not bringing them below. And, the counsel points to our side, but it's not our burden, right? If you go back to McLeod, it simply says that and the cases on equitable estoppel, and equitable estoppel only applies to the statute of limitations. It is the burden on a motion to dismiss for the plaintiff to offer evidence. And the standard of review here for that decision of the trial court is an abuse of discretion. And I say there's simply nothing on the record that even comes close to pushing this court to turning over essentially the judge's decision of not taking up the equitable estoppel argument below. It wasn't developed, right? With regard to the contract, there really is no evidence that, I've been confused for several years now to try to understand what the plaintiff and the appellant in this case is really arguing with regard to the contract. Other than they essentially argued again and again that the plan wasn't consummated. But the issue is, did the bankruptcy court enter an order saying that under the bankruptcy rules the plan was substantially consummated? And the answer to that is a clear yes. They want to kind of, as the court pointed out here, confuse the two. They didn't argue that there was fraud in the bankruptcy court or there was fraud in this in this at all. They didn't develop any facts. So there's nothing here. Again, where we stand is that this case, this breach of the note is now 10 years old, and this is the third time that they have been sued on this case. And finality at sometimes needs to mean finality. I think for both reasons, as cited by the trial court, the defendants should win, and you should confirm what the court below said. I'll take any questions. I think you understand the case.
I have none. Counsel, thank you.
Thank you.
With that, we are going to take the matter under advisement at this time. Thank you very much for your argument, and we will be issuing a decision shortly. Thank you.
Thank you. Nice to meet you. See you, Darrell.